Good afternoon, everybody. Thank you for being here. Thank you for joining. Thanks for paying attention to my many messages on WhatsApp. I told you I just seem to pop up everywhere. So thank you for being a good audience and entertaining me and Africa in the Moot. Welcome to the 9th educational training session that the Educational Program Committee runs. We are incredibly lucky today to have Professor and Dr. Emilia Onyema with us, sharing her experience and wisdom on preparing for and delivering oral arguments. Now, Emilia's resume is extensive, so I could only really give you highlights because I think we need to prepare probably a PowerPoint presentation in several hours if we were to go through everything in one moment. But I'd really encourage you to read her papers, the publications, and to follow her many activities. She's one of the most proactive and active African practitioners and academics in international arbitration. And, you know, this is the only time I would really encourage you to spy, and when I think spying is okay. So please do connect with her after this call and find out more. Just briefly, because also Emilia is very humble, just to give you some of her highlights before I hand over to her, our guest of honor. Emilia is a Nigerian national, and she's qualified in Nigeria and is currently now based in the UK. And she's also qualified in the UK as a solicitor of England and Wales. She holds an LLB, a master's, and a PhD, and that's how she's earned her title doctor. But she has, of course, another very important title, which is that of professor, and that speaks to her current role, which is Professor of International Commercial Law at the School of Oriental and African Studies at the University of London. And we have another title which refers to Emilia, and that is the one of arbitrator. She's acted in multiple arbitrations as a presiding arbitrator, a co-arbitrator, and also a sole arbitrator, and is on the panel of many reputable arbitral institutions, such as the Nairobi Center, Kigali, the Asian Center, Dubai, and Abu Dhabi. And this is also in addition to her many memberships in wonderful arbitral organizations, including the Arbitration Association, well, African Arbitration Association, and the African Fund, Arbitration Fund, my apologies, for African students, which is one of the valued sponsors of Africa in the Moot. And another title that she holds, and then I will really stop talking and give her the floor because she's far more interesting than I am, is that she is an author. So she has published multiple books and book contributions and blogs and academic articles. And I think it's just someone that you can all really learn a lot from. And I encourage you to absorb the session as a sponge. She is a very dear friend of Africa in the Moot, personally and through her organizations, and we really are so privileged to welcome her here today. So please ask your questions. As always, you're welcome to put your questions on the chat if it's not possible for you to speak yourself. You are also invited to raise a question if it's very pressing while she is speaking, but otherwise there will, of course, be opportunity for questions at the end. And we will open the floor. So if it is possible, we'd like to see your face. Hopefully it's smiling, and we'd like to hear your voice. And now with that, Emilia, I hand over to you.
Thank you very much, Erin. That's very generous. And good afternoon, good morning, good evening, wherever you are. And thanks very much to Arbitration, to Africa in the Moot for this invitation. So my topic, I know you've been preparing, you've done, for those of you participating in the Moot, you've already submitted made your written submissions, you've submitted your memoranda. And so we are now at that stage where we're preparing for the oral hearings and oral submissions. So I'm meant to be speaking with you this afternoon on how to prepare and deliver effective oral submission. So we prepare, we deliver effective oral submission. I have a few things. I'm just going to sort of speak for maybe 15, 20 minutes thereabout, and I will take questions and we can have exchanges. And even if you want, if anybody is willing to practice maybe an opening submission, the way you've prepared it, I can give feedback of what I think. Okay. So if you recollect that Erin said to you, I'm qualified in Nigeria. In Nigeria, I'm qualified as a barrister. And what that does for me is that the job of a barrister is to make submissions on behalf of somebody else. And so I think that is really key, because that's what you're going to be doing as in the moot. It's not your dispute. You're making submissions, you're representing a particular viewpoint. So you're not neutral. You're not the arbitrator. The arbitrator is required to be neutral, but you, as the advocate of one of the parties, you're presenting the facts, the law, from the perspective of that party. So if you're speaking for the claimant, you're speaking to the tribunal on behalf of the claimant. And you're bringing to the tribunal's attention the viewpoint of the claimant. The same if you are speaking for the respondent. So what exactly are you doing? You're telling a story. That is what you're doing. You're telling a story, but from the perspective, from the viewpoint of either the claimant or the respondent. And so for your story to be effective, you have to be able to communicate effectively. And for you to communicate effectively, there must be particular points, particular issues, particular facts, particular law that you want to communicate. So if I'm trying to communicate something to you, as I am trying to do this today, or to Erin, I need to ask myself, what is it that I want Erin to remember when I finish? So over the next 15, 20 minutes, what do I want her to remember? I want her to remember 1, 2, 3, 4, 5, howsoever many. And that is your structure. And so if what you want Erin to remember, what you want me to remember that you're speaking to me as the tribunal. Then the question becomes, the first thing is, this is the point, that is point 2, this is point 3. And so you build a structure, you have to have a clear structure that I want to communicate X, Y, Z. Then how do I get to X, Y, Z so that it is structured and I am carrying the tribunal with me? And when we say you're carrying the tribunal with you, what we mean is that the tribunal can hear me. They understand what I am saying. They're following my reasoning, the way I have structured it. And they can see where I am headed. And that is basics of communication. So if I come and today, what I want to communicate to you is how you prepare a story that you want to deliver orally. So, and for how you determine whether the story I'm telling you I have communicated is that's the effectiveness part of it. So it is this story, which means I need to know where I am headed. What is the conclusion? What is the summary? What is it that I want the tribunal to hear? And so you know where you're headed. So that's the first point I want you to remember. So 2 things I've already said. The first one is ultimately you're telling a story from the perspective of one of the parties. Okay? And you're telling this story to the tribunal, not to the other party, but to the tribunal. I'll come back to why this is really important. And so the key thing is, where is this story taking me? What is it that I want the tribunal to remember when I finish? And that's your 1, 2, 3. You then build a clear structure. And so you're telling a story, but you're not telling the story like a child. You know how a child, you'd say, oh, how was school? Well, we woke up in the morning and then we did this. And then mommy said, and then daddy did, that is all over the place. That is a child telling you a story, and you're trying to piece it all together. We've moved away from that. You're not children, you're adults. And so an adult telling you a story builds up the story to get to that conclusion that the adult wants you to take away with you. And that is important. So I'm not going to use the example of the moot scenario, but let's say I have a client and my client had delivered goods or had prepared to deliver goods. And in the contract, there's a force majeure clause. And we were meant to deliver in 2020, but COVID. And so because of COVID, the country where we're meant to deliver the goods at closed their borders. And my clients have been sued for lack of delivery. So what is it that I want the tribunal to, what's the point I want to make? We are relying on the force majeure clause. So what exactly is the problem? The problem is not COVID. The problem is that the governmental measure that was taken by the government in the place of delivery prevented us from delivery. It's not COVID. COVID is a story. That is why government shut down. That's not why we didn't deliver. We did not deliver because where we were meant to deliver, the government shut down. So which means we have to be clear why we did not deliver. And so we then communicate that clearly to the tribunal and see whether that falls under or within our force majeure clause. And so that is what we mean by a structured preparation for effective oral communication. Okay, so the key thing to remember is that you're communicating. It needs to be structured. The story you're telling has to be structured. It has to be joined up. It has to be, it's a story wherein what you would find is that you're hitting certain markers so that when you draw the various lines, it would all join up. That is, it has to be logical. It has to be properly reasoned. And then you're using short sentences. You can see that I am not reading a whole paragraph to you. I have notes that I have made, but I'm not reading my notes to you. I'm looking at my notes so that I can pick up the points and make sure I don't forget anything from the notes. But I had already prepared, and I had prepared over and over to ask myself, how do I want to connect the story that I'm going to tell you this afternoon? And so it is logical. I am using short sentences. I am pausing. I am demonstrating. You can see I'm using my hands, my face. I'm demonstrating to be sure that you're with me. I'm looking at you. I can't see your faces, but hopefully you can see mine and you can hear me. I'm not speaking too fast. Running away is like, okay, I don't want you to catch me. No, I am slowly taking my time and communicating. So that's the first thing that you want to note. The second thing you would have noticed, I've tried to be clear, to choose my words and to make them, simple, straightforward language that you would understand. And that is communication. Because if you're speaking too fast, or you go to the dictionary and just to impress the arbitrators, you pick up high-sounding, convoluted words that you then have to explain. It wastes time. It breaks the discussion up, and it's not free-flowing. It's not helpful. But so clarity is really important. For you to be clear, you have to know where you're headed. Do you remember what we said about what are you trying to communicate? And then the other thing to think about is you're presenting an argument, okay? You're making a submission. There would be facts that do not favor your client. So what do? You don't pretend as if those facts do not exist. So if, for example, in the example that I'm using, my clients had undertaken that regardless of what happens, they would deliver. That is a contractual undertaking that they have made. And the other party, the purchasing party, had said, it appears that the government may close our borders. Can you try and see if you can hasten the delivery so that you can deliver before the 10th? Because we have information that the government may close the borders from the 15th. And your client and my clients did not bother responding. That may be a circumstance or information that would not favor my client, but I must have an explanation. There's no point pretending that that communication never happened. The communication happened. And so the question then becomes, what is the explanation? Why did we not respond? Maybe we did not have capacity to produce or purchase the goods. It might be the fault of a third party, or that was not our contractual undertaking and we just could not change. That is something that I need to be able to understand and be able to communicate, be able to explain. The other thing is, how do I use the law? Remember that it's not, yes, you're telling a story, but you're telling a legal story at the end of the day. So there are facts that you are applying to the law. So I have already mentioned the contract. I've mentioned our own undertaken under the contract. I've mentioned force majeure, and I've mentioned the actions taken by the government. And so the question then becomes, how do I bring in the law? And we know that there is hierarchy to the law. So we know that if there is an international convention that is binding on us, or positive law that is binding on us, or a set of rules or trade practices, and then we want to know, is there any decision that can help explain or can help the tribunal understand and interpret the actions we have taken in our favor? We bring in those, we look for that case. Remember that in arbitration, it's not a national court. So arbitrators are not bound by the decisions of national courts, but they're persuasive. And so if courts have consistently interpreted a particular set of rules or law in this way, that is a strong persuasive tool to give to the arbitrators, because they will be more amenable to interpreting it in that same fashion. If that interpretation does not favor our own position or our own viewpoint, well, let's not pretend we can't see it, because remember that the other party would know about it. So what we want to do is we want to explore it and then see whether we can distinguish our own case. Is there something different from our own case and the case where where the courts made the decision that we want to avoid? Can we invite the tribunal not to be so persuaded by that decision, and why? Again, it is that story. We're trying to present another perspective to the tribunal. We're not running away from it. We recognize the weaknesses of our case, the case law that is against us, or even legal commentary that does not favor our position, but we need to be able to explain. We need to be able to distinguish. We need to be able to persuade the tribunal not to adopt that particular explanation or interpretation. Then you sort of begin to think about it. The other point that I want us to bring is to the fore is the reasoning. So it has to be rational. If we're asking the tribunal, yes, it's true that this court, the German courts, the Nigerian courts, the whoever courts have interpreted this clause this way. But we think we want to, we think that the tribunal should look at it in this other way. Then it has to make sense. It has to be logical. It has to be persuasive. It has to be something that at least the tribunal can consider. And that is really important. To enable you to do any of this, you have to know the facts. So by now, you know the facts in and out. You can work with the documents. You need to have read it over and over and over. And read it very quickly, and then you start reading it deliberatively. And what that means is that as you read each sentence, you're sort of thinking about it. And what that does for you is that it imprints the facts in your memory, in your mind. You're envisioning the transaction. You're envisioning, okay, when the meeting held and things like that. And then you know the documents. You know where the exhibits are. In your own bundle of documents, you have underlined, you have colored, you have made little notes, you have queries that you have written for yourself as you are reading, things that jump at you, things that just don't add up to you. But that is the starting point. You need to know the story. You need to know the facts. You need to know the materials that you are working with. Always remember that you have lawyers on the other side. And so they know the story. They know the facts. They know the materials. And assume that the tribunal knows the facts. The tribunal knows the material. And you get this all the time in the moots, where you have participants who have not really, grasped the facts of the material. And the tribunal is saying, okay, can you tell me if there's anything in the document that says XYZ that you just said to the tribunal, and you're scrambling? You should be able to take them to exhibit this page, this line, that. And that is important. And then that takes me to how do you work with your teammate? How do you communicate with the person, your whole person, to the tribunal? And that's where we sort of non-verbal communication skills would come in. And so you're speaking, but remember that you're speaking to the tribunal. And you're going to get a 3-member tribunal. It is true that there's a presiding arbitrator, but the presiding arbitrator alone cannot make the decision. It's not a sole arbitrator. It's a 3-member tribunal. And so don't get fixated with the presiding arbitrator. You have 3 members. So, sort of make clear eye contact with the three of them when you're speaking. And the advantage of eye contact is basically recognizing the person you're communicating with, and they can connect with you as well because they can see the conviction coming from you as you make your submissions. Your teammate, the person sitting next to you, their job is to listen, to give you prompts, to look out for time. I'll come back to the point about time, and to support your submission. So we had a team from SOAS once at the Moot, and one of the members of the team was making the submission, and the other member it was almost as though she was going to swallow her colleague up. She was, vigorously nodding her head and, looking intently at her colleague, and we're like, okay, slow down, you need to step back a little bit. Because yes, you agree with your colleague, but ultimately it's irrelevant because you're playing a supportive role, but don't be consumed by your colleague because it can't distract the tribunal from hearing what your colleague is saying. But you want to be sure that you're checking time. So remember that it is the participants that would agree at the time allocation. Most tribunals would ask if you have agreed how you wish to allocate your time. So you have chosen that time, so stick to the time. If for any reason, especially if the tribunal decides to ask you lots of questions, if for any reason you're running out of time, then you do need to ask for additional time, but don't ask for additional 5 minutes. That's too much. Maybe additional 1 or 2 minutes. So that's important before you run out of time. But try not to run out of time. Try to get your points in. For you to be able to get your points in, especially where you're getting lots of questions, it means you have to be flexible. Remember, I said you prepare, you structure yourself, but you might get an interventionist tribunal that will say, okay, they asked that question. Don't say to the tribunal, I'm going to come to it. No, you answer the tribunal's question, because in asking that question, that is what the tribunal is interested in at that moment. And when you answer the question, you're also showing the tribunal that you know the facts, you know the law, you understand what you're doing, and that you're flexible. Now, if you answer that, you don't need to go back to deal with it again. Just cross that off, that has been done, but link it back to your storytelling so that, again, there's a clear narrative coming through. When you finish making your submission and your opponent or opposing counsel is submitting, your job is to listen, and to listen carefully to what they are saying, so that when you come to rebut, you pick up from what they have said, which means you're listening, and tribunals get impressed that you are actually listening, okay? And when they cite a case that favors them, I think it's important, not that I think, it is really important that you show awareness of that case and try to distinguish it if there's any need, or you present a counter decision from the one that they have submitted to the tribunal. And when you come to do a SOAS rebuttal, you don't need more than one relevant point to respond to. And sometimes there's nothing to respond to if they haven't made any submissions that you need to respond to. So the last thing I want to say is to remind sometimes this comes through in the mood, do not be unprofessional and use thinly disguised words to insult the other party. Remember that it's counsel that you're acting as counsel, and so don't use flowery words or they should have known if they had done their homework. No, it's irrelevant. It wouldn't score any points. If I was the arbitrator, that actually is a minus from me, because I just don't feel comfortable with people talking that way. But it's to be professional and to stick to the dispute that is before you. And I think that is massively important. So I think taking my own suggestions into account, I've almost run out of time. So I'm going to quickly recap. And in recapping is again to remind you that when you finish making your submission, you have to summarize. And summarize, pick up from the 1, 2, 3 points you started out with and go back to those. Because I'm an academic, I prefer to raise questions, to say, we're going to ask this question, and then at the end, I can tell you what the answer to the question is. And so if you think of writing an essay in school, you start with your introduction. This is what you provide context. This is what this dispute is about. This is the view, the position of the claimant or the respondent. So that's the body. This is what I will do. And we will conclude. We'll try and answer those questions. So your submission and the questions that the tribunal would ask you and the answers you would give are the body of your essay. And then usually your essay must have a conclusion. And your conclusion says, this is what we've done. So introduction, this is what we're going to do. Body, you do it. And then conclusion, this is what we've done. And so, you can see why asking questions is a lot clearer. So these are the questions or the issues we're going to engage with. You engage with it. At the end, these are the answers from the perspective of the claimant or the respondent. And so, to conclude, remember that you're telling a story. Your story needs to be clear. You need to have a clear destination. What do I want this tribunal to remember when I finish? That is the goalpost. So if you're a football fan, that's the point where you're you're moving the ball in that direction. The net is, this is what I want the tribunal to remember. It doesn't have to be more than 2, 3 points. This is what I want to leave them with. And you keep going back. So they use certain keywords, if you wish, that you keep repeating and you keep repeating that. And that would be quite helpful. So that's what I've said, the story. Know the facts, know the materials, know the law, be flexible, and ensure that you speak clearly and that you take the tribunal on that journey with you. Be satisfied when you finish that, yes, they understood what I was saying and they would remember X, Y, Z. So that's, thank you very much. So that is how you can prepare and deliver effective oral submissions. I would now hand back to Erin. I think we have some questions and I'll be happy to take some questions. Erin.
Thank you very much for that presentation. It's very, very helpful as always. I expected nothing less from you. I think who has a question that they would like to raise now? I'm looking for hands up. while people are readying themselves, getting themselves to their screens, I can perhaps ask a question. I think from the perspective of managing nervousness, perhaps you would like to share with the students your story from your first appearance in the Nigerian courts.
Okay. It's becoming a popular story now. So when I qualified in towards the end of the 1980s, my first appearance in court, I was all wig and gowned and everything, got there, got up, and I forgot my name. I forgot everything. I froze effectively. I was standing before the judge. It was a packed court. I couldn't remember anything. I couldn't say a word. I was very lucky because I was appearing before an older gentleman, a judge, but he was really very kind. I'm sure he's seen that regularly each year. And so he said to me calmly, Ms. Onyema, you were going to tell me your name. And then I said my name. And then, I went to move a motion and that was it. So it happens. So I talk a lot now, but it hasn't always been like that.
I think I remember you told me that when we met in person for the first time, and that's something that also stuck with me, because I understand from the students in this experience that they have, this is the first time, it's the first exposure for many of our students to presenting an oral submission, and that is a different thing. It's a different style of communication, indeed, and can be quite nerve-wracking also, depending on who your tribunal is. So I think it helps a lot, certainly from more seasoned practitioners, to be able to share with the students, like, this stuff happens. You can even forget your name. So if you forget what the exhibit is called, that's also something that happens too.
Yeah, you're absolutely right. And don't beat yourselves, again, remember that it's a moot. That's the first thing. Yes, we say that, but it's also a competition, and we understand that. But just remember, take a deep breath and say to yourself, I want to enjoy this. That's what I say to my students, when we had teams that went for the moot. First and foremost, you have prepared. You have participated in, you've squared off other teams. So it's not like you don't know the story. You know the story. You know your arguments. And by the time you get to Vienna, everybody will be citing the same cases. So, it's very transparent. You know that. And so what can go wrong? It's you. And so I said to them, relax and enjoy it. And just do the best you can. What we want to see is incremental progress, that you can see that, oh yeah, okay, I'm better relaxed. I could communicate better. I'm not speaking as fast and all of that. That's what we want to see.
I have, before I see Barbara's hand is up, but before we move to Barbara, it's another question from Team Nairobi as well, which I think you may have answered. It's how, if you have any pointers on what to do if your hands shake, how do you handle that? Is it also a self-pep talk?
So if your hands, which a lot of people, you'd find that their hands shake. People have different techniques. And so what I do when I'm nervous, because it's just a sign of nervousness, that's what it is. It just manifests different ways. Some people, when they're very nervous, their voice, it sounds as though their voice is a bit shaky. And so what I do, if I feel nervousness, is I take a deep breath. I just sort of suck in and take a deep breath and then release, slowly release the breath. And then I just sort of say to myself, what's the worst thing that can happen? And it's my own way of helping me relax. Some people would hold on to the desk. Some people do that. If you've watched that, what's the lady that insured her backside for $1 million or how many dollars? No, not before Kim Kardashian. They're married. Oh God, what's her name? Jennifer Lopez. When there was that movie where she was a hotel manager or something and married some senator. That's that movie, The Wedding Planner. No, is it? Anyway, one of them movies. And in that movie, the senator was teaching her son how he dealt with nervousness for public speaking. And he said he had pins, safety pins in his pocket, and he would hold on to those or something like that. So people have different ways of dealing with that. But if your hand is shaking, you can hold, don't show that your hand is, you can hold your hand on the desk like that.
Great. I don't know if I'm shocked or impressed that we've mentioned the wedding planner in this training series, but let's just roll with it. I'm impressed by your knowledge. Barbara, over to you. I see your hand is still raised.
Okay, thank you so much, Erin and Ms. Onyema. That was very an insightful session. And thank you for answering the question on the hands shaking. It actually came up before in our team, and I believe the question was asked on my behalf. My personal question is in regards to having a roadmap when making submissions. How do you balance between wanting to be clear and guiding the tribunal on what you're submitting about, while also being conscious about time management? Thank you.
Thank you very much for that question. Time management is a huge one for people in the mood. I think it's used when you're preparing, time each point and sort of say, okay, we've agreed 15 minutes and I have 3 points. So I'm not going to spend more than 5 minutes on 1 point, and then sort of practice. Now, what you would find is that when you get to Vienna, it's not going to happen the way you've practiced it when you're sitting there for various reasons. It's not going to happen that way. So it goes back to that being flexible. And so you then, one other thing you can think of doing is which ones are the most important points. So you sort of have a hierarchy of points. The ones that you must get through to the tribunal, and the ones that are fine. If I forget those, that's not a problem. But these are the ones that I really want to hit. You start with those. I think that's important. And don't worry, remember that the moot, you have a written phase and an oral phase. And so the tribunal would have received your written documentation anyway. They're still doing that way. So the teams that you would act as arbitrator or serve as arbitrator, you would receive their written submissions. So hopefully they would have scanned through it at the very minimum.
Barbara, does that answer your question?
Thank you so much. I believe my question was more in regards to a roadmap.
Okay.
If I'm making my submissions and I'd like to guide the tribunal, and I'm saying in this issue, I will make my submission in these limbs, or would it rather be more preferable to just state the conclusion and say, for the following reasons? Yes, because when you decide to use roadmaps, most of the time you intend to take so much time in guiding the tribunal. But then let me.
I think you need to start with a clear roadmap. So remember what we said about the introduction. So it's important that the tribunal is clear. So you have 3 points. So I'm going to start with point 1. And then when you finish with point 1, just have a short summary to say you finished with point 1, you're not moving to point 2. So I had a professor once who said, when you do these things, sort of, it's almost as though treat the tribunal as though the tribunal is a child and you're holding the tribunal by the hand and you're walking them through your submissions. Does that make sense? Yeah. And so start with the roadmap, which needs to be clear. Point 1, you finish with point 1, you've now finished with point 1. You're moving to point 2, which is this. You finished with point 2, you're now moving to point 3. And when you summarize, go back to the roadmap, because that's what you want to leave them with. It sounds a bit tedious, but it's really helpful, because that way the structure is clear and the tribunal can follow that argument, and you're holding them by the hand. You're saying to them, we finished with part A, we're now moving to part B. Remember that that's your job. As counsel, it's not the tribunal's job, it's your job. So even if it sounds tedious, it's a better way. Don't assume. Yeah, does that help?
Yes, it does. Thank you so much.
We have a question from Ricardo from Team Mozambique. Ricardo, do you want to pose the question yourself, or shall I read it out?
Yes, thank you. Thank you for the lesson, Professor. And my question is related to when we have questions from the arbitrator. I think many times we have a difficult on how do we manage to answer the questions completely and not lose our sequence on the oral submission and the pace.
Yeah. Okay.
Yes,
so I think, yeah, if you go back to the roadmap, so some people are visual people and some, are not visual. So if you're a visual person, you can draw it out on your paper, okay? And you have it in front of you. This is how I want to run my arguments. These are my 3 points. These are the sub points, okay? And then when a question comes, you look at your roadmap that you have in front of you. Which one is that question referencing? You cross it out. Just use a pen, cross it out, because what you're saying is that, okay, so this is where this is, and you can see how it links back to your main submission. You cross it out, and then you try to answer, but short answers. Go straight to the point, answer. I think what catches us out is that when we are asked one question, we go all over the place. But if we can just sort of, okay, this is the question. I'm trying very hard not to mention the scenario that you're going to deal with in Vienna, because we're not meant to. So this is what the question is. So, for example, let's go back to the story I was saying, and the tribunal says to me, Ms. Onyema, what exactly is the force majeure point? What's the circumstance that you're latching onto? I can start by, well, then COVID, and the government said this, and the government did that. That's telling too long a story. Because I'm not interested, my story, the force majeure is not COVID. That's the government's business, why they locked down. That's their problem, it's not my problem. My problem is that the government shut their borders. It was unforeseen. And then I hit the technical requirements that the force majeure clause says I need to hit to claim that. But I know exactly what it is. The other party will be saying, well, there was COVID and governments everywhere, it was reasonable, blah, blah, blah. I'm not interested in that. I'm the one claiming force majeure. COVID is not my problem. My problem is a governmental action that I could not surpass. So you can see that because that clarity is there, when I'm asked that question, I don't go all over the place. I just hit it straight. The basis of our first force majeure claim is governmental action. They shut down their borders, full stop. And so you go back, you have your outline, you cross it out. And so if you're lucky and the tribunal isn't, not even if you're lucky, when they finish asking their questions, when you go back to your submission, nothing stops you from saying the tribunal has asked XYZ, we have answered that. And so then you go back to your submissions. It's how do you link it back to the structure? You just mentioned that has been done. And when you come back to making your submissions, remember that the tribunal already dealt with that. So just remind them that this point has already been dealt with in the question to enable you carry on with your submission. Does that sound like a reasonable plan?
Thank you. Helpful. Thank you.
Orga from Addis Ababa. Do you want to pose your question? Oh, okay, he's dropped off. I think maybe it's a connection issue. It was very anticlimactic. While we're waiting for him to rejoin, we can move on to a question from Marion from Team Cavendish, I believe. Marion, do you want to put your question to Prof. Onyema?
I think Marianne's question is in the chat.
Yes.
So Marianne's question is, how do we respectfully ask the tribunal to rephrase the question in case of not understanding it? And what can one say if he or she is unable to answer the question, like you don't know the answer to the question? Okay, so that's a two-part question. So how do you ask the tribunal to rephrase? One of the things to remember is that this is an arbitration, it's not litigation. And so everybody is seated. There is no raised dais for the tribunal. We're all seated on the same level. So it's good to be respectable, but not to give too much deference, if that makes any sense. Is finding that right balance. They're not judges. And so if they've asked a question and the question is unclear, can you just sort of say, Madam Presiding, can you please repeat the question? Or Madam Co-Arbitrator or Dr. Co-Arbitrator, can you please repeat the question? That's all. Ask them to repeat the question. Now, if they repeat the question and it's still unclear, depending on the presiding, if I'm presiding, I will usually jump in to clarify, okay? Because one of the learnings we have from the moot is that you have people whose first language is not English, and people who naturally speak really fast. And then you have people whose accent can be quite difficult to understand, which is why just the same suggestion I made to you earlier, we also make to arbitrators to speak slowly so that we can understand what is being said. And a question can be, when it's long, when you've asked a very long question, so you've built the context and you ask the question, everybody has forgotten the context. And then, so that's when it becomes really difficult. It's like, what on earth are they talking about? So don't pretend that you heard if you didn't hear. Ask them to please repeat the question. If you still do not understand the question, just say to them that I'm really sorry, but I don't understand the question you have just asked me. Okay, and then they will try to ask again. If they ask and you don't know the answer to the question, which you should know the answer to the question because they're not meant to ask you anything outside of the moot scenario. But if they ask a question and you honestly have zero clue of what they're talking about, say to them that at this moment, you can't think of an answer, but that you may come back to them on that. I think that's an honest answer. And that's really your core counsel might know the answer. Now, if you know the answer, please don't jump in because you're not the one speaking. Don't do that at all. Just write the answer. So you will have to agree how you're going to communicate with each other as long as you don't talk to each other, but write it down. Write the answer down. And you that you're speaking, remember you've already told the tribunal, can I come back to that to answer that question? Carry on with your submission. And then you now go back and say to the tribunal, you asked me X, Y, Z, and I said I would come back to it. This is my answer to your question. Do we understand? Yeah? Okay.
I think that's very helpful. Seeing a message. Marion says thank you with a smiley face. The most important part of the thanks. And Borga, I see you are back. You are famous. We've been waiting for you. Do you want to put your question to Prof. Onyema?
Okay, so Borga's question is in the chat. So
yes.
Borga said, oh, are you ready? Okay, Borga says, how, Borga is having internet problems. Says, how are we supposed to respond to completely new arguments from the other side, which we have not seen addressed, especially if we are respondent? Now, the moot makes it really clear, the parameters, the scope of what the hearings would be about. So you have to be very vigilant. If the submission of the other party is outside of what the preliminary order number 2 has set out, you have to bring it to the attention of the tribunal. And then you can say to you don't interrupt at all. When it's your turn to report, you then go back to that submission and say to the tribunal, take them to procedural order number 2 and say to them that the submission that the other party, your opposing counsel has just made is outside of the scope of procedural order number 2. If the submission is within procedural order number 2, it is just that it's an argument or a submission you've not heard of before, then you are in trouble because which means you haven't prepared adequately. And so you need to be able to think on your feet. You know the law, you know the facts, you need to then find an answer to their submission. As long as it falls within procedural order number 2, you cannot say, sorry, we're hearing this argument or submission for the first time, and so we're not prepared. Your job is to prepare and sort of explore various angles by now.
Does that answer your question, Borga? You can give us a thumbs up if possible.
Is Borga back?
Yes, he's alive from, or maybe he's a bot. He's alive. I actually, does someone want to ask a question? Okay, no. I actually have one as well, which I think could be of value to the students. Many of the teams are now involved in several pre-moots, which are taking place, and they take place in different, well, they're hosted in different jurisdictions. So for example, the ICDR pre-moot happened yesterday. And then we have, of course, Nairobi coming up in 3 days' time. And thereafter, there's the Mauritius pre-moot hosted by the PCA, Moscow, etc. Do you have any advice regarding, well, the importance of culture and jurisdictional background when addressing arbitrators? So you touched on something earlier about mentioning, for example, Madam Chair or Dr. Co-arbitrator. How would you suggest that the students address their arbitrators, and does cultural background or jurisdictional background matter?
In the mood, we see cultural background. And again, we also see lack of familiarity with arbitration. So for most of the students, this will be the very first time they are actually involved in some semblance of arbitration. And so would see things like Your Excellency, Your Honor, Sir, all of that, absolutely not. Which is why I said that, remember that we're all sitting on the same level. There's a reason why the tribunal sits on the same level as the parties in real life arbitrations and in moots. We're not sitting, the arbitrators are not sitting in a raised dais like a judge would sit, representing higher authority. It's not. We're all private citizens. We're all individuals. It's important to get that distinction clear. However, the arbitrator is the one making the decision. So whether you like it or not, you're making submissions to them. You're trying to persuade them to see things from your client's perspective. So there's some degree of respect that needs to flow between the arbitrators and counsel, and arbitrators would address you properly. You know, they would usually address you as claimant's counsel or respondent's counsel. And so you have three arbitrators. There's co, there is presiding, and there is a co. And so you don't need to know their names. And so just to refer to them as Madam Chair, Mr. Chair, I just prefer to say Dr. Chair, because it's easier. If the person is not a doctor, they don't get offended. If you call them Mr., if they are a doctor, people really get offended, and understandably, because it's a lot of work to get that doctorate. So I don't risk it. I just address people as doctor. If they are Mr., then they might say, oh, don't worry, I'm not a doctor. At least you then know. And you can call them Mr. Co-arbitrator, but just presiding co-arbitrator, Madam Chair. Please don't call the female chair Mr. Chair. Please don't do that. That is massively important. Please don't do that. No, it's Madam Chair.
That's great advice. Are there any other questions before we release Emilia into her Saturday? I keep my eye on the participants list and wait for hands to be raised.
Okay. And can I just say, Vienna is a beautiful city. It is really, really beautiful in a quirkish kind of way, but it's one of my favorite cities in the world. And it is neat. I live in London, so when I very much appreciate neat cities. Vienna is very clean. Enjoy Vienna. Walk around, go to the museum, take loads of photos. It's an experience. Meet people. Don't only stick with, or you go out in groups, yes, but speak with other colleagues, other students. Speak with the arbitrators. They're human beings, you know. They do all the things that you and I do. They have the same bodily functions, you know. So speak with them, and they want students to speak with them. Pick their brains. Talk about career prospects. What do you want to do? Hear their own stories. And once you get back after my preference is that same evening, if you have time, send them an email and say, we met at wherever, and I introduced myself to you. Thank you for giving me your business card. Recollect something that you people talked about so that they can connect that, and just keep in touch. That is the advantage. That is what this is all about. And it actually works. People have made great friends, you know, good contacts, gotten jobs and things like that, internships, placements, you know, but I enjoy it and take loads of photos.
And all of the same, of course, applies to Nairobi. Do you have any tips for the teams on what to do in Nairobi or things to pay attention?
I already saw that from your program. You're going to be eating at the carnivores. If you love meat, that's where you need to go to. But go to the national park. That is really important. You might find yourself doing a little bit of safari. I'm not sure that this is the migration season of the animals, but it is out of this world. It's an experience that is worth taking. So try and do that, and take lots of photos. Lots of photos.
There will be for sure. You can there. That's another moment I encourage spying is you can follow us on LinkedIn and see all the updates.
Yeah, that's how we would know what you guys are up to. So
great. I see no further hands raised, so I think we can conclude here. Emilia, thank you very, very much. I need to find a new word for thank you on my own behalf and on behalf of African the Moot and all the teams that represented here today. We really appreciate that you give us your time and your energy and enthusiasm and your wisdom and advice, of course. That's very, very helpful. And we look forward to seeing you and hearing from you soon. And of course, I'm sure that we certainly will keep in touch as an organization as well. But I really, again, encourage the students to reach out to Emilia as well.
Thank you so very, very much and enjoy the experience. Welcome to the arbitration world.
Great. Thank you.
Thank you.